All right, well, thank you everyone for joining us for Marking Your Territory, talking about trademarks today. All right, so we are the Shasta-Cascade Small Business Development Center. We are a nonprofit organization. We provide confidential, no-cost advising and training services for small businesses. We're funded in part by the SBA as well as the state of California. And then this is just some of our local team here for Shasta and Trinity County. So lots of great experts to pull from, you know, whatever questions you have. We usually have an advisor who can help. And then we can also pull from, you know, advisors in the Northern California region as well. And then we do have to start off with this disclaimer. So I'm going to go ahead and read this. The information provided in this webinar and any supplementary materials provided to registrants are intended for educational and informational purposes only and does not constitute professional, financial, or legal advice. No registrant should act or fail to act on the basis of any material contained in this webinar without obtaining proper financial, legal, or other professional advice specific to your situation. The Northern California Small Business Development Center and our host, the HSU Sponsored Programs Foundation, specifically disclaims any liability, loss, or risk, professional or otherwise, which is incurred as a consequence, directly or indirectly, of the use and application of any of the information presented in this webinar. All right, and then I will turn it over to our presenter, David Welker.
Thank you. That was Emily Christensen, by the way. I don't think she said who she was. Emily works with us here at the Small Business Development Center. She basically runs the office and is amazing. And yeah, we do have confidential advisory services. In our case, we handle Shasta and Trinity counties in Northern California. But if you're not in Shasta or Trinity County in Northern California, there is an SBDC near you. There's nearly 1,000 of them across the country. So if you have any questions about your business, you know, the services are free. So Google your local SBDC, find out who they are, and take advantage of the services. You've already paid for it with your tax dollars, so might as well take advantage of it. That's a little bit about me. Nobody cares about that, so we'll continue. I do want to say one thing that I kind of need to say. I'm not an attorney. And typically the disclaimer that comes with saying you're not an attorney means that if you take the person's advice, you're an idiot, right? So I'm telling you now, I'm not an attorney and I'm not giving you legal advice. I have, however, had some experience with trademarks and experience with intellectual property. And so I think I can answer some questions you might have. And I can certainly guide you in the right direction just based on my own experience. What we're going to talk about, we're going to have a short introduction. I'm going to talk about what a trademark is, talk a little bit about what they do. You're going to look at the differences between what's called a common law trademark that everybody pretty much has if they're using the mark properly, versus a state registration versus a federal registration. And if we have some time, we'll talk about infringement and dilution. And if you have any questions as we go along, put them in the chat. Emily will, if she deems appropriate, she'll interrupt me and ask the questions. Otherwise, I think there's a couple of stopping places where we can take some questions as we go along. So let's get going. Want to make sure everybody understands trademark is intellectual property, and intellectual property is an asset. On your balance sheet, it's called intangible assets. It's something that brings value to your company, just like a patent or a copyright. Those are intangible assets. Cash is an asset. You protect your cash by putting it in a bank. Inventory is an asset. You protect your inventory. Equipment's an asset. You maintain your equipment. So yeah, we should maintain our intellectual property just like we do other assets that our businesses have. You protect your inventions with a patent. You protect your writing and your idea expression with a copyright. And you protect your brand, your words, phrases, symbols that distinguish your business from others. You can protect that with a trademark. And that's what we're talking about here. And I want to make sure we understand the differences. A business name here, when you have your business name, you typically will register it with your state or with your local municipality, your county with a fictitious business name or something. And that's how you register your business name. Your domain name registers your internet domain, your www. whatever your website is. That's your domain name. A trademark is can be the business name, but it is a different registration. It protects your brand, and it protects the name regionally or nationwide. So I wanted to make sure we understood a little bit of the distinctions there between your trademark, which can protect your business name, your logo, your slogan, and some other things as well from other things like your business name and your domain name. So let's get into a little bit. What is a trademark? This is directly from the U.S. Patent and Trademark Office. It's a brand name or a distinguisher. It can include a word, name, symbol, or any combination in use or intended to be used to identify and distinguish the goods and services of one seller or provider from those of others, and to indicate the source of those goods or services. Okay? A word, symbol, or a brand that distinguishes one set of goods or services from another. So a trademark protects your brand. It can be a word, it can be a name, it can be a name of the business. I mean, something about names. You can't trademark your name except under some very specific circumstances. A symbol, you can even trademark a sound. It needs to be unique and non-generic. And it is used to distinguish or identify one brand or another. The key thing that the U.S. Patent and Trademark Office looks for when you're registering a trademark is to avoid confusion in the marketplace. That's the basic idea of a trademark. They want to avoid confusion in the marketplace. You can register it when it's in use. You can file an application when you intend for it to be in use, but it can be registered once if you're using the mark legally in commerce. So a little bit of a summary here. How do you get it? You get a trademark by using it in commerce properly without infringing. You have the option to register it with the U.S. Patent and Trademark Office. You don't have to do that, but you can, and we'll talk a little bit more about that later. What does it protect? It protects a word, phrase, symbol, sound. It even protects smells in some cases. Those are hard to get, but there are some trademarks on smells to distinguish your product or service from someone else. And if you're protecting a product, it's called a trademark. If you're protecting a service, it's technically called a service mark, but for the sake of our presentation, we're just going to call service marks and trademarks by the same name, trademark, make it easy. And in fact, as long as we're talking about smells, Play-Doh, in case you didn't know, trademarked their smell. If you ever played with Play-Doh, you can kind of think about what their smell smells like, right? And they have a registration. The number is 5467089 if you want to look it up. And it covers, quote, a sweet, slightly musky vanilla fragrance with slight overtones of cherry combined with the smell of salted wheat-based dough. Sounds like something you'd see on a menu at a fancy restaurant, doesn't it? But at any rate, Play-Doh trademarked their smell. They were successfully registered the trademark for their smell. And there's some others as well. There's a company that was able to get a registration for their trademark for bubblegum scented jelly sandals. At any rate, most common trademarks are words, phrases, symbols, and those types of things. How do you get it? Well, you earn it through using it, and you can register it if you want with the state, your local state, or with the federal government. And what rights do you get from it? Basically, no one can use your mark to sell similar stuff or to try to blur or tarnish your brand. Those are the rights you get from your trademark. So a trademark, like we said, is a word, symbol, or phrase or other characteristic. This is a list, this is a list of some trademark names along with the generic names and the people or the companies that own them. For instance, rollerblade is a trademarked, registered trademark name. The generic name for rollerblade is inline skates, and it's registered to Nordica. Scotch tape is a trademarked name belonging to the 3M Corporation for clear adhesive tape. So a lot of these names are in common use now. People talk about ping pong or tasers or Teflon. Those are trademarked names. They're registered trademarks. And just an interesting little side note there, something I thought might be of interest to you. Words, phrases, or symbols that distinguish one brand from another. You have a trademark that keeps you from drinking Pepsi when you wanted to drink Coke. It differentiates things within an industry, CBS from NBC. So it distinguishes one brand from another. They're creative and they're distinctive. The idea is you see them, you know what it is. Let's see if this works. The 4 sounds from Intel constitutes sounds that are trademarked. I don't know if you'll be able to hear this or not, but we'll give it a shot here. Let's see. Oops. Sorry about that. Okay. I don't know if you could hear that or not, but if you could, and you recognize that, those are the 4 sounds from Intel. There's a whole page at the U.S. Patent and Trademark Office, USPTO.gov, that has lists of sounds that are trademarked. The MGM Lion roar, the 3 tones for NBC, a lot of different sounds that have registered trademarks. They've registered the sound. The trademark has a meaning that immediately calls a product or service to mind. Think different for Google, KFC's finger licking good. This one's a little older. Where's the beef for Wendy's? Those were trademarks that were registered that would immediately call the product or service to mind because of the marketing of those logos or business names. And the idea of a trademark is that the trademark is valid within a class. For instance, if you think of the term Apple, you may think of Jobs and Wozniak, or if you're of a certain age, you might think of the Beatles and Apple Records. And so these are both registered trademarks. Apple is registered under a class for electronics, software, computers, that type of thing. And Apple Records is entertainment, music. So they're in different classes for their trademarks. How long do they last? They last as long as you're using them. I'm told that Stella Artois is one of the oldest, if not the oldest, active trademark in the world. Originally was used in 1366. Some of the newer old trademarks include Levi Strauss, their little design you see there from 1886. Shell Oil Company has been using that shell since 1904. So the trademark can continue to be used. There's no expiration as long as it's continued. It stays in place as long as it's continued in use and not abandoned. The trademark is still active. So let's get into it a little bit more. Your trademark identifies your brand and how you're perceived in the market. It identifies you, your company, and your product. It can be your business name. It can be your logo. It can be your tagline, your color scheme. It can be elements of your product, smells and sounds. Those are more difficult to get, by the way. smells and sounds. Smells are really hard to get, but I mean, we talk about your color scheme. John Deere was able to register their green and yellow trademark for their landscaping class, that type of thing. UPS registered brown for transportation, UPS brown, so that someone else within their industry couldn't use their brown color and create confusion, that in the market in that area. So yeah, so your brand, for most people, your brand's going to be your business name, your logo, your slogan, your tagline. Those are going to constitute your trademarks. Now, some trademarks are easier to get than others. The first kind that's easiest to get are words that, apart from your business, mean basically nothing. Kodak is an example that they say. Google, although there is a Google is a term that means a very large number. It's the way it's spelled, and that it's considered non-generic, and so they're typically easier to get. When you talk about what they call arbitrary marks, you're talking about marks that by themselves make sense. The word United, the word Apple, those are real words. But if you think about United, the word United as it relates to airlines, well, there's kind of arbitrary. There's no real connection there, just on the surface. Apple compared with iPads or iPhones, there's no connection there either, really, on the surface. Those are arbitrary marks. Those are a little harder to get, but they're still easier than, say, what they call suggestive marks, the kind of marks that suggest what the business or what the product might be able to do for you. A couple of examples: Caress for toilet paper, I won't get into that, and Coppertone for tanning oil and sun protection. Those are a little more difficult to get because they actually suggest what the product does, and so they're a little more difficult to get. They have to, they may have to put up a little bit more of a fight to get the registration from the Patent and Trademark Office. Very hard to get are trademarks that basically describe what it is you're doing. Computerland, Radio Shack are a couple of examples that are frequently cited for trademark registrations that were very hard to get because they basically identified what it was they were selling. Computerland sold computers, Radio Shack sold radio parts. So those were more difficult to get. And trademarks that you will not get registered are generic ones: RV park, hardware store, grocery store. If you sell computer monitors, if you try to trademark, you try to register for your trademark the name computer monitor, you're not going to get it. They're generic, and so they're very difficult to get. Why don't we just pause there and see where we're at? Emily, do we have any questions in the chat?
No, not currently.
Okay. Well, let's talk a little bit about how we get trademarks, about whether you need to register them or not, and how that's involved, how that gets going, how you do that. If you're using a trademark right now, you have a name for a store, and you're the first one to use it in commerce in your area, and you're using the mark legitimately, you have common law rights to use that trademarked name. And if you've ever seen a logo or a company name with a little TM there, that indicates that that company, that brand, that belongs to them. That's their trademark. That's what that TM means. It's not registered necessarily with the government, but they're asserting their common law rights, and they have protection. If it's legitimately used where they're using it, they have protection where they're using it because they were using it before anyone else, and they were using it there in commerce. You can register it with the state. You can file to register your trademark with the state. We're in California, and state registration will grant you protection throughout California. And basically what it gets you is the state will notify the public that you own that trademark within the state of California. And it draws a line in the sand for you within the state of California. There's a federal registration, however, that trumps the state registration. And if you register your trademark federally with the U.S. Patent and Trademark Office, then you are allowed to use that R with the circle around it, meaning you have a federal registration granted. And there are some benefits to that. You have national protection. If you're using your trademark properly, you have protection throughout the United States. You can use it as the basis for protection in foreign countries. And another nice benefit of having a national registration is you can let the U.S. Customs Office know that you have this registered trademark. And then if someone tries to import goods with your logo or under your name illegally, they can prevent the import from coming into the United States, which is a nice thing to have. So that's the difference between a common law trademark and then registering your trademark. An interesting story, and one that you may have heard about, certainly people in the trademark and intellectual property community tend to know about this one, is a story of Burger King. In the 1950s, in the early 50s, a little shop called not a shop, fast food place called Burger King was established in Mattoon, Illinois, and a little town in Illinois. And later, a few years later, Big Burger King started in Florida and began to expand and got a federally registered trademark and began to expand across the United States. Eventually, they ended up in Illinois. And there was a bit of a fight between Little Burger King and Big Burger King. And what ended up happening was the courts decided that, you know what, Little Burger King was there first. And so they have the right to the name Burger King within a 20-mile radius of Mattoon, Illinois. And to this day, this Burger King location in Mattoon, Illinois can operate as Burger King, and Big Burger King can't open up a franchise within 20 miles. I read an article recently, well, it's an older article, said, and it interviewed the owners of the Little Burger King. They said that at one point, Big Burger King offered them $10,000 for permission to open a store within their area, and they told them to get lost. So anyway, it's Little Burger King was there first. Had they filed a federal registration when they first opened, perhaps Big Burger King would be called something else. I don't know, Bun Queen or something. I don't know what they would be called. But anyway, little bit of a story. The idea is geography and registrations, and the first to the party. They were the first ones there, and they have the rights within a 20-mile radius of Mattoon, Illinois to this day. So there are some pros, as you might be able to see, from getting a federal trademark registration. There's a few cons as well. One of the pros is that you have protection nationally. You have the right to sue in federal court, and there's some benefits associated with that if somebody infringes on your trademark. I mentioned the U.S. Customs and Border Patrol protection. You have that if you federally register your trademark. The cons, you already have rights, trademark rights through the common law rights. So it's not like you're buying anything except further geographical protection. If all you're going to do is sell in a certain area, maybe it's not worth it to get the federal trademark. There are fees to acquire and maintain the federal trademark. And I've gotten federal trademarks, and you will get a lot of unwanted solicitations, and you will open yourself up to a lot of people that will want to scam you out of some bucks, and that can be annoying because once you federally register your trademark, because it becomes public, and then you'll get people saying, hey, you need to renew with us. It's going to cost, it becomes nutty. So there are some cons associated with getting a federal trademark, but overall, for most people that I've spoken to, I've found that it's worth doing. So let's talk a little bit about how you get a federal registration. Assuming you have a brand that is registrable, okay, you're using it properly in commerce, you have the rights to use it. The first thing to do is probably to conduct a search. Make sure that there's nobody else out there using the name. You can search the USPTO.gov database. They have a trademark database where you can search within the class that you're going to be looking for. If you're in transportation, say, you can look within the transportation class and see if there's other companies that have trademarked the same name within your class. You can search online. Go onto Google and see. That's probably the easiest way to do it. And remember that federal registration, their goal is to avoid confusion in the marketplace. So one of the things they'll look for is a homophone, a word that sounds the same. So, and they may turn down registration because your company name sounds like another company name within the same class, even though they may be spelled differently. I had one instance, talking about the next one, foreign languages. I had one instance where I was helping a company, kind of guiding them through the trademark process. And this isn't the name of the company, but it illustrates what happened. We looked up the company name. We did a search, couldn't find anybody using the name of the company within the trademark database or in Google. It looked free and clear. Everything looked great. And the examiner came back and denied the trademark because the name was being used, but in a different language. I gave an example here. The name Duke, that wasn't the name of the place, but if we tried to register Duke, basically they came back and said, actually in Mandarin, there's already a company named Ganju that is in the same classification. And so they said, since Mandarin is a language that's spoken throughout the US and it's a common language, there could be confusion, and therefore they denied the registration. So think about that. Consider some foreign languages. Consider similarities, visual similarities, and just remember when you're doing your search to make sure you're free and clear. The Patent and Trademark Office's primary criteria is to avoid confusion in the marketplace. So you want your trademark to be unique, and you want it to be, it's obviously going to be of value to you. You want it to be unique, and you want it to make sure that when people see your trademark, they think of you, they think of your product, and they don't get it confused with somebody else. And that's the primary thing that the Patent and Trademark Office is going to look for. So you've gone through the search, you've determined that you're free and clear. Make sure you know what classes you're going to want to go after. Maybe it's probably just one, it might be more than one. LegalZoom has a really good list and description of the different trademark classes, and you can click, you'll be getting copies of these slides, and you'll be getting a copy of a link. You'll be getting a link to where this video of this webinar will be. But at any rate, LegalZoom has a good list of the trademark classes and what they cover. And there's 45 of them, numbered 1 through 45. One of them, they might be, I don't know if they can't think of them offhand. They might say medical devices and then have a list of different types of medical devices that particular class covers, or restaurants and then descriptions. So when you get into it, take a look at that link. It'll help you determine the class that you might want to go after. Now, if you're going to do the registration yourself, there's an application you can do online at USPTO.gov. You can do it on paper, it costs a little more, or you can do it online at USPTO.gov. Or you can go to LegalZoom, have them do it for you, or you can hire an attorney to do it for you. Those cost more. But if you want to do it yourself, USPTO.gov has a series of videos on how to fill out the application. The videos are, in my opinion, somewhat cheesy, but they are very, very good in terms of the information they provide. They give you everything you need to know about submitting a trademark application. If you go through the whole series, you'll learn a ton about trademarks. It's worth doing. And the other thing, if you do decide to go for an application and do it yourself, don't be intimidated right away. It's my own personal suggestion. Remember that the application you're working with has 2 strikes against it already. It was designed by an engineer, and it was designed by an engineer who works for the government. So it's not user-friendly. Okay? It just isn't. It doesn't look to be. Okay, let me back up. It doesn't look like it's user-friendly, but it actually, in reality, it's easier than you think. And it's not as onerous as you might think. And the reason is, and I think you'll understand as we go through, one of the first things, for instance, that comes up, it asks you, are you an attorney? And so if you answer no, a lot of the questions that are supposed to come up next, they skip it and they go to the next one. So it isn't really as bad as it appears like it might be on the surface. So don't be too intimidated. Going through the application, it'll ask for information, the owner of the mark and the address, information about the mark. Is it standard word? Is it a special logo? Is it a phrase? What specifically does the mark consist of? And it'll ask for the class at that point, what kind of good or service it is that you're applying for, and ask what class it belongs in. It'll ask for a basis for filing, a 1A or a 1B. 1A means you're using it now in commerce. 1B means you're going to use it in commerce. It costs more to say 1B. If you wait until you're actually using it and then file 1A, it costs less. If you hit 1B, you have a certain amount of time to use it in commerce. And if you don't use it within that amount of time, you have to ask for an extension, and it can get very expensive. So probably best to just, when you're using it, when you're using the mark, to do 1A and then say, yes, we are using it in commerce. They'll ask you to upload a specimen showing the overall context and how the mark was used, describe it, what was the date when it was first used, and anywhere, and the date that it was first used in commerce. When they say upload a specimen for overall how it's used, they're looking for something like a product, a box or something that you're selling with the mark on it, with the logo or whatever, or a price tag or some kind of specimen showing how the mark is used. There's rules surrounding it. If If it's a product, just showing the product logo on a website may not fly. It needs to be on the product itself, showing how the thing is sold. If it's a service, however, a logo on a brochure might suffice. So there are rules surrounding that, but that's the next step in the application. After that, correspondence information, an oath swearing that everything you're saying is true, and then you got to pay them, and the U.S. Patent and Trademark Office will send you an acknowledgement of your submission. How much do you pay them? Well, the fee is going to depend on a number of different things. It's the U.S. Patent and Trademark Office considers every variation of a trademark as a different trademark. So like the word Starbucks is a trademark. The Starbucks inside the logo is a trademark. So you need two different applications. That's what we're trying to show here. So every variation needs to have a separate application. Every class within, if you're going to go after 2 or 3 classes within each trademark application, you need to list those. And there's something we'll note here. Starbucks, I don't know if you can see this, they actually filed a registration for Starbucks coffee in apparently in Chinese characters. And they're saying this means Starbucks coffee in English. They actually have a number of different trademarks, dozens probably, registrations that they have filed with the federal government. So yes, each one requires a different filing. So your fee is going to depend on the number of applications. It's going to depend on the number of classes. Each class will incur an additional fee. And the type of form you use, whether it's a paper form or an online form, your filing basis, we talked about that. Using it in commerce is the cheapest. If you're going to wait, there's fees for you're intending to use. Now, if you're going to file one trademark application in one class, it can be as low as $250. If you're going to do 2 classes, $500. So, and if you use an attorney or outside help, obviously you've got to pay the attorney or you've got to pay LegalZoom, so you need to pay those fees as well. And there's a series of other fees that, depending on whether you're able to file the whole thing at once or whether you have other issues like the intent to file, that you may have to pay. But there's a fee schedule at USPTO.gov, and it's not that difficult to figure out how much it's going to cost. Once you have your ducks in a row, you'll be able to see what you're looking at. You should also know that there are more fees that they'll get for you. After you file, between 5 and 6 years after you register, you have to pay a maintenance, you have to do another filing, a maintenance filing, to let the U.S. Patent and Trademark Office know that you're still using it in commerce, and you pay the fee. Another one is due 9 to 10 years after registration, and you'll have to pay the fee again. After that, it's every 10 years. To keep the trademark registration active, you have to continue to make those filings and continue to pay those fees. If you have any questions about this, there's a number of places you can go. My experience with the U.S. Patent and Trademark Office has been nothing but positive. They've been extremely helpful. They won't give you legal advice. They won't advise you which what you should file and what you shouldn't in terms of your own marks, but they will help you through the process. And they're really, really good about helping you through the process. You can always hire an attorney as well. You have to pay them, but you can hire them. You could use an online service like LegalZoom. You have to pay them too. And you have to put up with their future marketing efforts to try to get you to file more trademarks or go with them to file a patent or whatever. But they're effective, and you can use them, or you can contact your SBDC. Many SBDCs have experts in this area. We in Northern California, we have, and as part of our Tech Futures group, we have a patent attorney who works with us, an intellectual property attorney, and he can help answer questions that the advisors can't, some very technical questions. So we can't give legal advice, but if we have the answer to the question, we'll try to get it to you. So we've got, looks like a little over 15 minutes. How are we doing on questions there, Emily?
Yeah, so we do have one question here. Someone asked, if one has a trademark, do they also need a copyright? And what is the difference between the two?
A trademark protects your brand. It protects your identity. The copyright protects the actual words. The actual language that's there. So you have, interestingly enough, copyrights have the same common law features as a trademark. So you have a trademark, and the fact that you're using it, you're the first to use it, you have an inherent copyright already anyway if it's a phrase. It's there, but the trademark protects the brand and keeps others from using the same brand. I had one of my favorite taglines. There was a barbecue place in a place where I lived. Their slogan was, "The best dang barbecue ever to make contact with the human lip." It's my favorite tagline of all time. And they and that was their trademark. And the fact that they came up with it means that technically, I suppose they would have a copyright, but the trademark, the fact that they have the trademark is really where their real protection is going to be. A copyright is going to be for actual words, for actual, like a book or a pamphlet, words that are actually, written out and keep somebody from actually copying that. If somebody were to copy your logo and use it for their own logo, they'd be infringing on your trademark. That would be the right kind of intellectual property to protection to go after. I hope that answered it, and I hope I didn't confuse things. It can be confusing. Anything else?
No, I think that's it.
All right, we've got a little bit of time, so why don't we look at a couple of cases that I found interesting, cases of infringement. There's a violations of trademarks. The two most common terms I've heard them called are infringement and dilution, and we'll talk a little bit about each and how they help protect you and how, as a trademark owner, and how they protect the consumer as the user of products. Infringement protects the consumer. It's when someone tries to make people think you're buying their product. Probably the most interesting, in my view, case of what they called infringement was recently New Balance sued a Chinese company who were selling sneakers that looked a heck of a lot like New Balance sneakers. And they were successful in suing the company, which is really interesting because the company was in China. And they were able to sue a Chinese company and win because there was confusion over authentic New Balance shoes and these other shoes in China. And the Chinese government agreed that there was a possibility of real confusion there. So that's what infringement does. And you can see, I think you can see, these shoes have the New Balance logo and an authentic New Balance. I mean, come on, they were obviously infringing. Dilution has more to do with the way when the mark is blurred or tarnished. There's an example from a few years ago. You have Ben & Jerry's ice cream. Well, a porn company came out with a series of videos that they called Ben and Cherries, And they put out a bunch of pornography with what really looks like Ben and Jerry's logo. Ben and Jerry sued them, and they had to stop the videos and they had to pull them off the shelves. And it was because it was obviously tarnishing the Ben and Jerry's mark. Other forms of dilution are, it's protecting the mark. Dilution protects the mark. Other forms of dilution can seem like infringement as well. Nike has their Just Do It logo. There was a shirt company a while back that wanted to say Just Jesuit, and Nike sued them, and because they said it was dilution, it was too close to our mark, and Nike won that one. So those are a couple of cases of infringement and dilution, and how that helps protect you. And it's best when the trademark is registered, because that's the federal government saying, yes, we recognize that this is a valid trademark. So that's what I have. So do we have any other questions or any other comments? Actually did that a little earlier than usual.
If you have any questions, you can put them in the chat.
I will say, let me put this up here. Feel free to contact us, especially if you're in Shasta or Trinity counties. This is our website. This is Emily, her email. This is our phone number. There is an SBDC near you, though, no matter where you're at. So if you're in another state, or if you're in another county in California, not in Shasta or Trinity counties, there are SBDCs near you. So feel free to contact them. You can go to this site, which is the National SBDC site, americassbdc.org, and you can find it there. You can probably also find it just by Googling it. We have a LinkedIn page, we have a Facebook page, we have a Twitter page, and we have a YouTube channel. So, we're in the 21st century, man, I got to tell you. So feel free to check those out as well. Like I said, you'll be getting copies of these slides. So, yeah, that's what I got. Anything, last chance for questions?
We do have one more question before I get to that. I did just put a link to our survey in the chat. So if you guys could help us out and click on that, let us know how we did today, and then if there's any other workshops that you're interested in. Okay, so this question, I've always heard that geographic domain supersedes arbitrary usage. For example, if someone is using a name that has no real meaning where they are, like a state or town name in another state or town.
Okay. Can you say that again? I'm not sure what the question is, or if it's just, maybe it's a comment. It sounds.
Yeah, so does the geographic domain supersede arbitrary usage?
I think we're talking a little bit about, well, apples and oranges a little bit. If you're using your mark in an area, an arbitrary mark in an area, and someone else is using the mark in another area, and neither one of you have a federal registration, based on that and based on my understanding, they're fine where they're at and you're fine where you're at. And you have those common law protections. Whether it's an arbitrary mark or a coined mark or another kind of mark, not sure matters a whole lot in that case, if I'm understanding the question correctly. And I may not be.
All right, any other questions for us?
Okay.
All right.
Well, thanks. We won't keep you any longer than we have to. If you're working and you said you were going to do this for an hour, you have a few minutes to goof off. So congratulations. We'll let it go from. We'll let you go from there. Thank you so much for joining us, and appreciate it. And we'll let you go. Thanks. Have a good day.